everyone. So happy to be back here. So this is the second section, second kind of webinar, which is a wonderful webinar, by the way, of our new section, the fashion law, that I'm happy to chair. And here we have some of our most active members that are so much in the industry that will be able to give you a lot of insight and a lot of, things that you can use during your practice and you can be really super useful. So let me introduce them. The first is Fabiana Zangara. Fabiana Zangara is a founding partner of Zaka Law. She's based in New York and she works in Los Angeles as well. And she has an extensive experience in employment-based immigration matters. So basically, she take care of companies, fashion companies, for example, people that are key managers or director of the company. They need to move here and there from Europe, especially, and she's able to take care of it in a wonderful way. She was previously in a large international firm in New York, and she holds JD from University of Rome and immigration law from Cardozo Law School. And she's a lawyer both in Italy and in New York. Then Uduak Oduok, Uduak, sorry, my dear, is a fashion entertainment lawyer, is a former fashion model, and she's the founder of Fashion and Law, which is a boutique firm that serves fashion, music, film, and digital media industries. So she's a veteran in this industry, and I'm very happy to have her on board. She's a fantastic member of the fashion section, and she developed a lot of kind of content both in the San Francisco place, right, and the West Coast. So she was modeling law curriculum and created the first fashion law course in the California State University in Sacramento, where she's based, right? She advised on intellectual property, licensing, and talent agreements, and cross-border deals. In particular with the Afrobeats music industry, and she's a recognized speaker at institutions like SXSW, sorry, it's a long one, and the Fashion Law Institute and the Wharton School. Then last but not least, my friend Victoria Burke. She's a legislative reform advocate and privacy attorney that represents plaintiffs in class action involving data breaches and consumer privacy violation. She authored the Speak Your Truth Act, which I'm very proud of you, Vicky, groundbreaking legislation protecting survivors of sexual assault from retaliatory defamation lawsuit, which has been enacted in multiple states and is advancing toward federal adoption. She's an adjunct law professor and author in the U.S. Supreme Court H&M versus Unicolor case that I'm sure you very well know about that. And she bridges law, policy, and lived experience to safeguard truth, autonomy, and voice. So guys, I think it's enough for me, and I can't wait to hear your beautiful presentation. Thank you to all.
Thank you so much, Alessandra. Shall I? Okay, good. So nice to meet you, everybody. My name is Fabiana Zangara, and as Alessandra was saying, I'm the founding partner of Zaka Law, a full-service immigration law firm based in New York. It's truly a pleasure to be here, and I'd like to thank the Beverly Hills Bar Association, the Fashion Law section, and its president, Alessandra, for this wonderful opportunity. During my career, I've had the pleasure of working with many creatives from the world all over, from photographers to models, fashion designers, entrepreneurs. And what I love the most is helping them transform their vision into career opportunities in the United States. And today, I would like to share how immigration law interacts with fashion industry, sometimes as an obstacle, but more often as a bridge to build new opportunities in the US. And to start, let me ask you two questions. How many of you know someone in your fashion circle that started their journey here in the US on a visa? Or on the contrary, how many of you know somebody that had to leave the country because of visa issues? I cannot see you, but I assume that many of you know someone that had to deal with visas. And that is exactly why immigration law matters in the fashion industry, because behind every campaign, behind every collection or every show, there are people who needed a visa to be there. And in order to be more practical, I want to discuss with you and I want to show you some numbers about the global fashion market. So let's move on the next slide, please. So those are the numbers for the global fashion market. In 2024, it was valued at 1.77 trillion. And by the end of 2025, is estimated to be worth 1.84 trillion, which is approximately 1.63% of the world GDP. And by 2030, is projected to be worth 2.26 trillion. Those are huge numbers. But to remain in the US, let's take a look at some numbers from New York. So New York is definitely one of the undisputed capitals of the fashion industry. Just think about it. Approximately 900 fashion companies have headquarters in New York. And let's take a look at some numbers here. So over a population of 8.4 million and a workforce of 4.2 million in New York City only, approximately the 6% of the workforce, which is 180,000 people, work in the fashion industry. And these are huge numbers. And that is why there are some basics that we cannot ignore. The first basic that we cannot ignore is, if we can please move to the next slide. The first basic that we can't ignore is the fashion industry is global, and therefore mobility is an essential part of the fashion industry. But also, without proper visa strategies, opportunities are lost. And like no visa, no jobs. It's that simple. And that is why immigration is really important, because it turns borders into bridges to new opportunities for talent from abroad here in the US. And I'd like to share with you two stories from my clients, actually. The first one is Elena's journey. So Elena started, if we can move to the next slide, please. So Elena started her journey here in the US. Elena is a brilliant Italian fashion designer. So she started her journey on a J1 visa, that is a trainee visa. Eventually was able to secure an O1 visa, that is a visa for people with extraordinary abilities, and to self-petition her green card. So right now, Elena runs a famous studio in New York, fuels the local economy, and was able to secure like partnership with very famous brands such as Nike, Adidas, and other famous brands. On the contrary, Amada's journey was a little bit different because Amada is a brilliant fashion model from South America. She came to the US with a tourist visa looking for job opportunities, even though her visa did not allow her to work in the US. And so she was forced to leave the country and lost momentum, but also lost job opportunities. So what is the takeaway from those two stories? That without a proper visa strategy, we, like even talent, can lose job opportunities in the US. And so some of you may ask, okay, but what are the most common visa options, and what are the visa options for somebody that wants to work in the fashion industry? And I'm not here to be boring. We are not going to talk about the different visa requirements. I'm just here to mention some of them, and I'm sure you are familiar with some of them. There is the O1 visa, that is kind of an haute couture visa because it's designed, it's tailored on your extraordinary abilities. Then we have the H1B, we have the J1 visa, we have the EB1A, the E2, the L1. But so how do you decide what is the best visa option in your case? So there are two different things to take into consideration when it comes to visa. So the first one is the purpose of your trip. The purpose of your trip really makes the difference. But also the evidence that you have available really makes the difference as well. So for example, for creatives, having evidence of press coverage, exhibitions, awards, contracts, it's essential. On the contrary, if you are a company willing to sponsor a visa, then you need to consider your ownership, your international presence, the number of employees that you have. So the takeaway here is one size doesn't fit all. There is not just one visa, but everybody should develop their own visa strategy and be focused on the evidence that they have available. So it's not just one visa, it's different visa strategies. Okay, let's please move to the next slide. So I'd like to talk right now about the most common mistakes and pitfalls and misconceptions. So the top 3 mistakes that I see, especially in the fashion industry, are, first of all, waiting too long. Timing is of the essence, especially today, and having the right strategy in place really makes all the difference. So I cannot tell you how many clients wait until the last minute to think about their visa and to apply for their visa. So this is a waste, and this may trigger not just delays, but may trigger losing job opportunities in the US. So don't do that. Take some time to work on your visa case, and as soon as you realize that you need to travel to the US, it would be great to start working on your visa. The second most common mistake is under-documenting. So sometimes professionals, especially talent and creatives, think that talent speaks for itself. Unfortunately, this is not the case. USCIS doesn't know anything about the case, and they need evidence such as, again, awards, contracts, press, to prove your extraordinary abilities or to prove how stable is your company. If you don't do that, this may jeopardize your case and trigger delays, or, especially with the current administration, requests for further evidence that may lead to denials. So it's really important to collect as much evidence as you can in order to build your case. You need to treat your immigration petition like your immigration strategy as a brand strategy. It should be consistent, reliable, and backed up with evidence. The third common mistake is traveling without the right visa. It's definitely easier to secure a tourist visa. And if you are a citizen from some of the countries that allow ESTA, that is a visa waiver program, it's definitely easy to enter the country. But under those visa categories, you're not allowed to work. And if you do so, this may jeopardize your future entry in the United States. So it's definitely not worth the risk. Now, when it comes to misconceptions, I have selected 3 that are really common and come up all the time. The first one is you need a visa, you need a sponsor for every visa. And this is not the case. I've mentioned before Elena's journey. So she was able to self-petition her green card, that is the EB-1A. So for some visas, sponsors are necessary, but not every time. The second common misconception is if you're not Gucci, you do not qualify for a visa with extraordinary abilities. And again, this is not true neither. Why is that? Because we are able to prove extraordinary abilities at every level. You don't have to work just for a luxury brand in order to secure a visa or to prove your extraordinary abilities, provided that you have evidence, good evidence to prove them. And last but not least, another myth is you need to invest $1 million in order to secure an investor visa. That is false. We were able to secure visas for our clients and they have invested a much lower amount. Remember, the law only requires the amount to be substantial, does not specify a particular amount of money to be invested. So the amount is substantial if depending on the project and depending on the business plan. So we cannot determine before whether you are eligible or not, but definitely investing $1 million is not mandatory. Now, I have selected for you a few current challenges for talent and fashion companies, especially right now, today. So the first one is unfortunately longer processing time because immigration petitions right now are under strict scrutiny, and sometimes like an increasing and a growing backlog may trigger longer processing time. So this is definitely one of the current challenges. The second one is higher USCIS filing fees. Just to give you an example, the O1 visa is the most common visa or among the most common visas in the fashion industry. And before the filing fees, the USCIS filing fees related to O1 visas were $460. Right now, if the sponsor is an employer with less than 25 employees, it's around $830. If it's a sponsor with more than 25 employees, it's much more. So this is definitely a challenge for talents. Not to mention that if you want to opt for premium processing, there is an additional fee of $2,805. So like higher filing fees are a current challenge. And this is strictly connected to the third challenge, finding a sponsor, because right now, model like agencies and companies may be a little bit more cautious and skeptical when it comes to sponsoring new talents. And then the fourth and last challenge that I want to mention are tariffs. That is the elephant in the room, because tariff, of course, raise costs on imported goods and have a negative impact on sourcing and sales in fashion. So those are the four current challenges today. And okay, but how do we overcome the hurdles? And here are three pieces of advice that I give to my clients all the time. First of all, plan your collection. Having the right visa strategy would avoid delays because, as I was saying, timing is of the essence. So work on your visa strategy. The second advice that I would like to give you is mix your looks, meaning do not focus just on one visa type, but try to consider multiple visa options. Speak with an immigration attorney that can guide you, because by doing this, perhaps and being flexible, some doors that may have been closed may be open for you. So considering different visa options may definitely be a good thing for you. And last but not least, showcase your best pieces. Spend time on collecting the right evidence. Work on that, because your cases should be treated as plenty of evidence should be collected to support your achievements. USCIS doesn't know anything about your case, and those immigration petitions are kind of storytelling where you need to explain your story to the officers. If you don't do that, there may be an issue. And as I was saying, this may trigger delays and requests for further evidence. And now, to close this conversation, I want to share with you a thought that I share with my clients as well. The future belongs to those who are ready to cross borders and embrace new opportunities. Thank you so much for your attention. It's been a pleasure to be here. Please feel free to contact me if you have any questions or you need any advice. And I'll now leave the floor to my colleague, Uduak. Thank you so much.
Thank you so much. What an awesome presentation, Fabiana, and great way to take the baton and run with it to focus in on the talent model more specifically and on a domestic front. So let me start first with saying my background, as introduced, former fashion model, turned fashion and entertainment lawyer. So I've had an opportunity to really view things from a diverse perspective, but not only that diverse perspective, but also see the intersection of fashion, film, and music all coming to play. And where I want to begin is the question that's often always asked of me. And that question is, how do you get into the fashion industry? How do you become a fashion lawyer? And specific to models, please, if you could advance the slides to control of image. So specific to models, The first thing, and just generally as the fashion industry, is as a lawyer, it's important to understand that we're in the business of fashion. So you have to understand the business, not just the law. And specific to models, focus on control of image equals control of value. So what does that mean? In the fashion modeling industry, a model's image, their likeness, their photos, their name and persona is their product. So whoever legally controls how that image is used, licensed or sold, ultimately controls where the money and power goes. And as a lawyer, it becomes your responsibility to know agencies, platforms, media, and the law, so you can properly manage the contracts, publicity, and digital risk associated with that. So focusing in on the legal issues across the fashion value chain. Well, I think we just initially talked about the basic fashion value chain as a way of knowing that. So there are 4 stages of the basic fashion value chain. Number 1, raw materials. Number 2, design and manufacturing. Number 3, distribution and retail. Number 4, the auxiliary services. I'm zooming in on auxiliary services for purposes of time so that my colleague, Victoria, will have enough time to cover her part. So for auxiliary services, we are talking about marketing, media, trade associations, product testing, advertising, and consulting. Then we get into the legal issues across the value chain that are associated with each stage. And I want you to look at auxiliary services specific to what we're dealing with: advertising law, right of publicity, influencer liability, and unfair competition. Zooming in even more on that, what are the typical clients that you'll be serving? Typical clients that are in that space: brands, retailers, advertising and marketing agencies, media, and that includes publishing companies, influencers, models, testing and certification providers. Let's talk a little bit about where to find fashion models. Often people focus on traditional spaces, and the reason that that's relevant for you as an attorney, as you're thinking about representation or getting into fashion law as a whole, is you don't want to limit it to just traditional spaces. You want to look at digital platforms, AI, and future modeling. And why is that important to broaden your understanding? Because when you understand where models come from, you're now focusing in on the sourcing, which determines the rights that you're going to protect and the safeguards that you're going to build into your contract or contract negotiation for the model. So for example, if you are looking at traditional spaces, then you necessarily will invoke the California Talent Agencies Act. And what does that act do? It requires licensing, approved contract forms, trust accounts, and fiduciary duties. We'll get a little bit more into that. So it's so important to know where fashion models can be found and how that ultimately affects how you negotiate. So let's transition to the first core relationship that a model encounters in the industry. The very first one is the model agency relationships. I could tell stories for days, but in the interest of time, let me focus in on one of the key issues we see here. In this particular instance, when you look at France categorizes models as employees. The UK categorizes models as independent contractors, and the US does the same. But with that comes, needless to say, a lot of abusive practices. Some of it you probably have seen or heard in the news. So what have we done to try to remedy that? For the first time in a very, very historical way, you have New York that has enacted New York's Fashion Workers Act. And what it is a very comprehensive act that gives rights to models in a way we haven't seen before. The rights include deal memos, contract access, capped agency commissions at 20%, overtime pay after 8 hours, meal breaks, and the list goes on. And actually, let me even get it, focus in on a few more things. It used to be you go for a job assignment, and then next thing you know, it might take another 6 months before you get paid. The New York Fashion Workers Act allows you, as a model, mandates that you must be paid within 45 days of completing your services. and deductions require consent. So agencies can no longer sort of deduct everything, and by the time you get it, you barely have anything to show for your work. There are term limits on the contracts. Contracts are limited to 3 years. You can't have automatic renewals without written consent, which used to be the case before, and a lot of abuses in that way. In terms of artificial intelligence, which we'll cover a little bit on, you need written consent, and that's required for creation or use of digital replicas or AI images. A big, big issue, health, safety, and harassment. I can't tell you all the many times you're backstage changing, whether for a New York Fashion Week show or wherever the location of the show is, and you just have random people just walk backstage. They don't really care. They think somehow by virtue of sometimes purchasing the ticket to be VIP or whatever, it gives them access to come into the dressing room, which models have a problem with, but for a long time, their voices have been ignored. It's sort of like your clothes hanger, change clothes and go, and nobody cares really what's happening to you. So New York is sort of taking care of that part. Among other things, it requires that you have a right to safe working conditions, breaks, and freedom from discrimination or harassment as a whole. California doesn't have a carved out New York type Fashion Workers Act, but it sort of protects models through labor and employment laws, which we'll talk about briefly. So having said that, it's another key one is the Coogan laws. Coogan laws is specifically focused on, it's named after child actor Jackie Coogan, who earned millions in the 1920s, only to discover as an adult that his parents had spent nearly all of it. His lawsuit led to California enacting the first Coogan law, and that was in 1939, and ultimately a lot of states have adopted it. I'm going to zoom in on California. New York has adopted it, Illinois, Louisiana, New Mexico, but zooming in on California, California requires a blocked trust account, and that's required for minors in entertainment and modeling contracts. And then what the percent amount that will be withheld or expected to be withheld at 15% of the gross earnings that must be set aside. That amount must be deposited within 15 business days of wages, and applies to child performers, including models as of January 1st, 2025. Also, part of that is an expansion to include child influencers in online content. So we're making a lot of progress there, and there's similar laws specific to the Coogan law in other jurisdictions, as said. So what is the practice tip for you to really zoom in on that? For ensure that when you're drafting those contracts, they're auditable agreements. Also ensure that the enforceable protections for minors, really zoom in on minors. There's a lot of abuse. I got into the industry at 14 years old, and I can certainly tell you a lot of what I saw, we would be all gaps in right now. So it's very, very important that you focus in and protect minors as you negotiate these deals and ensure that there are those enforceable protections as well. All right, so let's transition into photography and models and intellectual property rights. Photographers as a whole own their copyrights, and models rely on the publicity rights. So there's always been a huge struggle with respect to, okay, what does that really mean for model rights? And more specifically, states that have adopted a right of publicity with the specific conflict are California with the California Civil Code Section 3344. New York has adopted, Tennessee has adopted, Indiana has adopted, as well as for all those states I mentioned, including postmortem rights. Other states don't necessarily have that. So you're dealing with federalism to some extent, actually to a large extent, federal law, which one trumps, does federal law trump state law? Copyright law is certainly more significant than state law. With respect to right of publicity. And for right of publicity cases, I wanted to highlight a few key ones to sort of underscore the challenges with that and then talk about a little bit of the takeaway there. So Russell versus Marlboro Books is a case that came out of New York in 1959. The model's photo was used beyond the scope of her signed consent. The image was altered and reused again. And the legal issue there was whether the use of a photograph outside the limits of written release violates New York's privacy and publicity rights. The court there denied the motion to dismiss, found that the release did not permit altered or additional uses beyond its scope. And so then we move on to the Canby Enterprises versus Matthews matter. And that particular case was where a website had reproduced copyrighted erotic photos of models without permission. And the plaintiff there owned both copyright and publicity rights. And the issue there was whether a state right of publicity claim under California Civil Code Section 3344 is preempted by federal copyright law. The court reversed that under summary judgment motion and held that Section 3344 did not preempt because likeness rights are different and distinct from copyright. Then you got the O'Neill case as well. In that case, that was a photographer that sued a model for posting his paparazzi photo on Instagram. By the way, that's becoming a very common scenario. And the question was whether in reposting the paparazzi photo of oneself, is that copyright infringement or fair use? And the court found that, it was essentially infringement and she could not use actually the court didn't find that. They settled that issue. But when that issue keeps coming up, we see that federal copyright trumps the right of publicity. Similar cases as well for the Ariana Grande situation and also the exposure photo agency involving Bella Hadid, as you can see in that slide. So practice tip here when you're looking at negotiating this specific type of deals, focus on licensing both the copyright and the publicity rights, ensure to define the media, define the scope, the media, the term, reposting, and AI. Let's go into another key brand relationship, and that is models, brand, and legal compliance. The issue here is usually involving the FTC. It's involving also how models are posting, how they're collaborating with brands to ensure that they limit legal liability, but at the same time do what they're supposed to do. Now, models have been really expanded in terms of the definition. So it's not just fashion models now, it's influencers, it's celebrities. Several cases to look at. I just gave you a synopsis, but the citations are in the slides, so please reference that if you want more details. So Fire versus Kendall Jenner, that was where the FTC found that there was an FTC disclosure failure and deceptive advertising. That was a very big case that ultimately not only made headlines, but got Kendall Jenner into trouble because she was hyping a Fire Festival that did not happen and basically was fraudulent and had deprived people of lots and lots and lots of money. So essentially, the thing there was FTC disclosure failure equal deceptive advertising. The Ultra versus Michelle Phan case involved a copyright infringement for unlicensed music in YouTube videos. And if you're going to use music in videos, even as an influencer, you do need permission for that. The Petunia case saw a fashion model on social media advertising for a brand. They worked out the brand deal, but in the process of her using the hashtag for brow boost versus brow boost, it turns out that she was infringing or allegedly infringing on the trademark of the defendant who sued. And ultimately, that matter was, I believe, settled. So practice tip there, build a compliance stack, make sure you have your trademark clearances, especially if you're working with talent, ensure that the copyright licenses are cleared, ensure that there's FTC disclosure, and of course, include those necessary indemnity clauses so that you don't have a client that has to deal with those kind of issues just by virtue of occupying exclusively an influencer role. All right, so let's transition into the models, discrimination, and health laws. In that particular case, we're looking, or the issue there is industry that pressures unhealthy body standards. And of course, unfortunately, what flows from that is also issues of harassment and lack of wage compliance. And in France, we do see a situation where France has been very, very aggressive in ensuring that if you are going to have an image of a fashion model, it shows that there have been alterations done, and you properly label that, in fact, an alteration has happened there. So for that, we look at some of the cases that might be helpful. I would say even when a modeling engagement is structured as a photo shoot, just generally as a practice tip to think about, or an influencer campaign, always treat it like a workplace apply wage, safety, and harassment prevention standards, require all vendors and agencies to comply with California labor laws. And so let's specifically run through a few of those labor laws. AB 2338. Actually, I'll just focus on two for time purposes. AB 2338, and that was enacted in 2018, effective 2019. The focus there was model safety and harassment prevention training that passed. So now talent agencies must provide sexual harassment prevention and retaliation training to models before job placement. I'll also focus on AB 2539, even though that did not pass, but the goal was to try to get us to a place where we have better laws governing health, safety, and body image standards. The idea there was that it would have required nutrition or health education and transparency around photo retouching. And then we've got California Labor Code Section 201-204, and that's timely payment of wages. And most of you are probably familiar with that. There's AB5 that recently passed that would technically have models seen more as an employee, but it doesn't apply to printing as well as runway models. All right, so let's get into wrapping things up with looking at AI and its impact on models, and hopefully that leaves enough time for Victoria to speak. I just want to highlight a few things here with models and AI and digital rights. The issue here is AI tools replicating likeness without consent or compensation, and then how do you discuss the scope of publicity rights, which remain really, really unsettled. And there are several cases to look at as well. One key one is the Kylan Young versus Neocortex case, a 2023 case where the dispute was over unauthorized likeness and use in a reface app. That's still an ongoing situation. Another one, just no litigation, but made headlines, and you can see the image there, which is the Jingnang Zhang incident, where the artist and model essentially had unauthorized deepfake likeness published in AI tools. Practice tip, AI is a big thing. Insert those AI clauses in contracts. Clauses should expressly cover explicit consent, digital replicas, revocation rights, and labeling. So let's see a little bit of the controversy that's been happening as a result of that. Is AI modeling, the world's first digital supermodel, and a lot of models are concerned about what that means for their jobs. And of course, if you're negotiating appropriately, then you know that you're carving out those right of publicity rights and being able to ensure that that model gets paid by virtue of their image being used to train AI, for example. Same with the AI modeling guest scenario, which is a huge controversy where you had this particular agency's Serafin Valora create this image for guest purposes, for Guess the brand, and using it as commercial editorial in a fashion magazine, Vogue. Of course, it raised a lot of concerns about not only beauty standards, but the replacement of models. Recent times in the film industry, we've seen the Tilly Norwood that's made headlines in recent times, and what the implications are for image and likeness. SAG-AFTRA issuing a statement saying Tilly Norwood is not an actor, has no life experience to draw from, no emotions. And there are already rules, just like we saw in New York, that are mandating and making it clear that if you are going to use images of talents for AI purposes, you have to, synthetic talents, you have to negotiate a completely different deal and also get consent. So compensation and consent are critical. And another really, really big issue that we've seen in the music space is the AI artist Zania Monet, who recently signed a multi-million-dollar record deal. And I think for me, the key thing is just addressing the issue of AI monetization. What does that mean? What does the compensation scheme look like? And how do we carve it out, looking at the core way that we essentially monetize intellectual property? So licensing and assignment of rights, what does that look like? I think that's where attorneys will really have to grapple with things. And so then conclusion, practice tip summary, I've already talked about those. And in essence, distinguish copyright from publicity rights, draft precise, verifiable contracts so compliance can be tracked, and enforce compliance with FTC labor and health standards, monitor digital use and AI replicas. And in fashion law and in fashion modeling law as well, images value and auxiliary services are where lawyers lock in that value for the clients they represent. Thank you so much. And on that note, I will pass it on to my colleague, Victoria Burke, to cover the legislative aspect.
Thank you. Well, we're noticing more and more with fashion apparel that a lot of the issues are being addressed in legislation, where they'll introduce a law or something to correct an issue that's been ongoing. And one of the biggest driving forces of this new tidal wave of legislation addressing the fashion issue is fast fashion. And you have probably heard of fast fashion and all of its issues, but one of the critical issues is it's mass producing a lot of apparel and garments. And so they're trying to figure out, how do we deal with this? Because it's using up a lot of environmental sources. It's using questionable dyeing and different ingredients. And, they're trying to keep track of for health reasons and what happens to the fashion. And so we're seeing this with the first law is California AB 405. And it was enacted this year, and it's the Fashion Environmental Accountability Act. And this one is important because it's having fashion sellers are required to disclose their supply chain. And that hasn't really happened before, where now you're having to disclose like who exactly is handling the dyeing of the clothing or the finishing, the printing and the washing and their techniques that go into it. There hasn't been this level of oversight or delving into exactly what goes into the manufacturing of the clothing. And now they're having to report it to the Department of Toxic Substances Control and the State Air Resources Board, and they would have to submit these annually. The tier 1 suppliers are where they are starting, but that's something that as a fashion retailer, you're going to think of, have we taken into account what is happening at every stage of our clothing? Could be that maybe you used a different country and just kind of trusted their manufacturing process and didn't really pay that much attention. Maybe you paid attention to what dyes were used, what chemicals, but maybe didn't realize like different states might allow certain things and it might have negative implications down the road. And now there's accountability that's coming along with it, and it's kind of catching up with the fast introduction. And you'll see a lot of laws are coming in through California, because California is pretty much fast fashion centered and fast production versus New York, which is more runway and that type of like fashion. So you'll see like the laws sometimes will reflect different issues as the states come across it. And if you can go to the next slide, and you'll see that this is a great demonstration of the impact to the environment from fast fashion. If you can see and zoom in, this is like the clothing dump in the Atacama Desert in Chile. So basically, companies are having people just use their clothes and just like, instead of like keeping them or reselling them, they're so cheap. A lot of people are just discarding them, throwing them out. And so a lot of times if they don't sell one season, or if they have extras left over, or however it can be, they'll have all these like articles of clothing, and what do you do with them? And so one of the ways they have found of disposing them is literally taking them to this desert and just dumping them there, because the country has made a contract that this is something, economically they benefit from. However, this is a photograph from space. That's how big it is. You can actually see the amount of clothing from outer space. It's getting out of control. So that's why a lot of states are wanting to address some of these issues. Next slide. And so California has introduced SB 707. It was enacted in 2024, and it's called the Responsible Textile Recovery Act. And it's going toward, what do we do with all these like extra clothing and so much, manufactured goods from fast fashion is just flooding in. So the program is meant to divert like textiles from residential and commercial waste and figuring out another way to dispose of them. So one of the ways is this law is encouraging producers to create a plan of how to collect, repair, and recycle their products. Different companies you'll often see might offer you incentives if you bring back your clothing, that they will give you a discount at their store to continue shopping, but therefore it will likely be recycled, some of this clothing, or they'll try to figure out a different way to use it. And the bill was first introduced to apply to apparel and textiles that were unsuitable and reused in their current conditions, such as like footwear, swimwear, undergarments. And so you would not be able to like resell these ordinarily, at least, unless to a very niche market. And so therefore, like, how do we handle disposal of these products? And some of the key mandates is that they will have producer responsibility, and they'll have to like check in and figure out how to institute different resource recycling programs that will recover it and manage this. Next slide, please. Now, New York has been trying to have similar laws. And one of them is called the Fashion Sustainability and Social Accountability Act. They've reintroduced it multiple times. And having had my own law passed, I have learned at different states, sometimes it takes multiple times to be introduced before it's finally passed into law. But this is another one where it targets the supply chain, and it's introducing transparency and due diligence. So as someone who is involved in the legal field with fashion, you want to consider it when you advise a client, you have these plans in mind when going forward, because they might have to present them like, okay, so you're producing all these clothing from where? How are your suppliers getting their chemicals, and what do they do? And like, you want to have that laid out, at least as oversight, that you advise the clients, and be aware that certain states have implications from these, and they might have fines if there isn't compliance. And the more states that tack on these laws, and they're a little bit different, it kind of leads to hard to navigate to make sure like we're compliant in one state, we're not compliant in another, because there's no federal law yet for something like this, though they are trying. Next slide, please. And then you had the Federal Volunteer Labeling Act, and this is proposed, not enacted, and it would establish EPA-led sustainable apparel labeling program at the federal level. Now, this is interesting, where you're kind of, letting the fashion suppliers and sellers do it themselves, like introduce their own guidelines of like, we'll label it and we'll say it. But one of the issues with a law like that is, you might have heard the term greenwashing, where they'll be like, our clothes are recyclable or made from recycled products, but it doesn't really say how much of a recycled product you have to use in order to qualify to be able to say this. What if you have 1% of your clothing or the aspects of your clothing are actually recycled materials? So can you say like, this is from recycled materials, or this one is like very safe? We have seen this issue. There's the with vegan leather is one of those that it's often being pushed as like an alternative, but vegan leather, some of you may not know, is petroleum based. So the oil companies think like, yes, let's push this as like the greatest thing, because like it's easier to recycle petroleum goods than it is some other goods. And so you'll see different ones will say we're environmentally good, but you have to look at who is promoting the environmental good. And it's a lot of times it's an interesting like background company, like maybe the oil industry is actually behind it. So you'll see certain types of goods being pushed, but you have to think of like who's pushing these goods and who is the one who wants the labeling, and what does it actually mean, this labeling, because it might not actually be as it's said. It might not be environmental. And then on the other end, you're having a different type of reaction of something called green hushing, where people are getting worried about being sued, different companies, for like false claiming like we are great for the environment, this, and some people are suing as this is false advertising and misleading. And so some companies are worried about being sued. And so they are starting to do green hushing, where they're not mentioning all the programs that they're doing to have their clothes like recycled, or the materials they get it from, because they have fear that they're going to be overly broad or overstated and somehow end up into litigation, which multiple companies have seen. So it's an interesting thing when you put it back on the companies, which is basically if it's voluntary labeling, it could incentivize consumers to make conscientious choices. But then again, you have to look into who's controlling the label, and if they're controlling the rating, are they actually benefiting from the rating system? Like I said, a petroleum one. Next slide. This is an interesting one. This is from California. It's SB 62. It's Garment Worker Protection Act. And what's interesting is that in California, you wouldn't believe how poorly some of the workers are treated. You don't need to even go to a different country to find workers being abused. And I've done a lot of pro bono work also for the apparel industry. And it's interesting to see that a lot of abuses do happen in our own city. For example, in one case, a contractor in Los Angeles was had paid garment workers as little as $1.58 per hour because they're doing piece rate wages. So maybe if you have an intricate outfit that takes a lot of sewing and you only do like one an hour and you're paid like $1 something an hour to get it done, you're only making $1.58. No matter how long you work on it, it's like, oh, you only get paid for that one item. I mean, it's, if you're making like little itty bitty things that go very fast, you can make more. So now they're making it so it's like you still get an hourly wage and you don't have to rely on just piece rate. And that's just was enacted in 2022. So changes are coming, but they're taking a while to get there. But again, if you see, California is leading the charge on that, and that's because we have so many fashion, producing like I was going to say, not sweatshops, but factories here. But we still have to police them and look carefully. And one of the ways that we're doing that is through legislation. And, again, as a fashion, lawyer or someone advising someone, you want to be careful about, who they employ for the labor. Make sure like they're doing the practices that should be. You'd be amazed to find out that, they have full understanding of what is required by law, but they are actually not doing that. Next slide. And switching gears a little, this has been a proposed law, the Federal Design Piracy Protection. This was proposed but never enacted for federal protection of fashion designs, because you see how many types of fashion designs are, on the runway, and then all of a sudden they're at Forever 21 and all these other ones, Shein.com, and they all look alike. So this was intended to kind of help extend like a copyright protection for 3 years for fashion design products. The problem is that there's such a quick turnover that it wasn't season today, it's not in season tomorrow. So whether or not people would want to register their designs or pay all that money to do that, if it's maybe a design that's not going to go anywhere, it ended up not being like enacted. I think there was a lot of pushback, and also in an industry where even the people who are against, counterfeits do tend to borrow sometimes from each other. Like, where does inspiration begin? It's very hard. I mean, current copyright laws protect pattern designs, if something could be removed from an outfit, and like if you could hang it almost like an art and that kind of design, then that's protected, but it has some protection, but not complete. Next slide. What's interesting is Michigan has been one of the first states to enact an anti-counterfeit law that was enacted in 2024. And it makes it a misdemeanor to knowingly purchase or possess counterfeit goods. This is a change. Usually it's the consumer is not held accountable. It's those who are selling it to the consumer. And this is the first change in the US and the first state that's enacted. It's surprising to be Michigan. I would expect like a different state, but you have to be aware now if you're in Michigan and you go somewhere and you're like, you are knowingly buying something, you could have like be fined up to a year in jail, to probably depending on how much you are buying. And so this is one of the first times that they're actually putting this on the consumer. Next slide. And this is also, Italy was one of the first to prohibit sales, import, even personal possession of counterfeit goods. And so they will enforce it against tourists. And I was just in Italy last month. I remember telling my friends, like, don't buy anything that you think is counterfeit. Like, they have laws against it, and they have like really high fines of like 1,000 euros to 12,000 euros. And like, we don't want to get tied up in this, but it's interesting, like the US is trying to shift to the way Italy possibly is looking at things of holding consumers responsible who are knowingly knowingly pretty much buying it. I don't know if it has to be knowingly, but like with the standards in Italy, but it seems like they're moving toward, if you're buying in certain areas, like let's say Santee Alley in Los Angeles, you might know that these are not where, let's say, the typical high fashion brands sell their goods. Next slide. And New York City, this was not enacted, but they did try to make the purchase of counterfeit goods illegal by consumers, where they would be punished, the consumer who did that, but it did not go anywhere. Next slide. And that is all for my presentation. I believe we're going to take questions now.
Okay, so it looks like we just have one question that's currently in the queue. It pertains primarily to AI. Jay Dodery begins with the concept that non-humans do not have a right to publicity. So AI models not based on real people must have no right of publicity. AI created works, okay, only have copyright in human generated components. What legal regimes do you view as available to keep a third party from using an AI quote unquote model? Trademark, unfair competition, or something else?
Yeah, I'll take that question, and certainly my colleagues can chime in as well. First, the three-prong, the question on whether I'm reading it, whether the public will be very receptive to AI models. I think yes. I think we're already seeing that. For example, the AI modeling, the Shudu.gram, the world's first digital supermodel. If you go on Instagram and look at the comment section, the public is like so receptive. It's like, whoa, sign me up. How do I, so specific to fashion models. On the one side, fashion models obviously have an issue with it. It directly undercuts them. And if you're not actually licensing or negotiating those image rights specific to AI, obviously there's a problem. But for the public seems quite receptive to it. Now, with respect to the other questions you ask on what the legal regime will be, I think you still go back to the legal frameworks we have. Let's start with copyright. If the work is original, then you still have to deal with the copyright infringement issue for purposes of, do you have consent? Is it do you have a license to, or is it an assignment of rights for that copyright? If you don't have that, then you have to concern yourself with infringement issues specific to AI. Is the AI being created original? For example, in the Tilly Norwood example, the creator of that keeps insisting that AI is art, and the idea that the creative industry will have such strong reaction doesn't make sense, because AI in and of itself should be recognized as creativity and should be protected accordingly as well. So there's a copyright framework to think about and use. I don't think right of publicity may fit as well. I don't necessarily see that fitting in as well. However, if we look at trademark and look at the standard of likelihood of confusion, I think you can take the likelihood of confusion, especially with your analogy on what if you put it in a pornographic setting. You can use that and say there is a likelihood of confusion on the brand as a source identifier of the initial brand you've created, and now somebody's copying, basically hijacking that and creating an identical brand that causes confusion and using it in the way that you're talking about as well. I think you also look at possibly trade secret law, depending on how that AI is generated and the data that's used to train the AI model as a whole. One could argue that the contract and confidentiality clauses in the contract impacts the outcome, and so should be protected. So that's another vehicle. And then I think the final vehicle is you default back to tort law. If you're harming my reputation or saying things that are defamatory or putting him in a false light, certainly I would think that's a very, very good vehicle to use for purposes of pursuing litigation and making that party stop. So that's how I would respond to that. Victoria?
I was going to add on to that about one issue I could see possibly down the line is false advertising. If you are doing, like, let's say, an AI generated model who is wearing makeup, if the makeup looks like it's making their eyelashes extra long or doing something that is like enhanced that actually cannot be duplicated on a real human, then I could see that there might be potential issues. Because I believe it had been, correct me if I'm wrong, in the past of models where they have to disclose if they did any enhancement or anything where it wasn't actually if they did any kind of editing behind the scenes or to make the makeup look like it was doing something more than it is. So I could see that down the line potentially being an issue with AI if it's like claiming the model is like showing the product can do something and maybe it actually can't realistically.
Yeah, and I see the subsequent question, Jay, on basically no copyright. Yeah, I mean, but you do have the bundle of rights on the reproduction right and derivative work as well. So I mean, you could make an argument. The point is, how do you potentially argue for purpose of AI? You could argue derivative work, even though yes, the AI model is not necessarily an original work, but you could argue derivative work or go under the reproduction right, I would say, for purposes of evaluating the approach on the copyright law. Obviously, we're still trying to figure out what to do and whether the copyright vehicle is a good vehicle, but I think that's a possibility to consider. And I think you had another, non-humans have no privacy rights. Yeah, non-humans have no privacy right. That's true. But if you're arguing that there is, if you're using tort law as a vehicle, you're essentially arguing reputational harm because your analogy was that you have someone that uses, based on what you said, put in a pornographic setting, an avatar. For example, what if someone took a recognizable avatar not based on a real person, okay, and put in a pornographic setting? If it's not based on a real person, then yeah, that's a different analysis. I would agree with that. But if it is based on a real person, obviously, then you could go after using defamation law. But if it's not based on a real person, that's a very interesting area and scope to figure out, and that would be interesting. I guess you could look at it from, I think you would probably maybe look at it under the umbrella of the creator themselves and maybe trademark law and unfair competition. 17200 under California law might be a vehicle to look at if it's not based on a real person.
All righty. Well, it looks like we're done with questions. Thank you so much for your time today and for sharing your knowledge and expertise with our audience. I'd like to also thank our audience for joining us today. Have a great afternoon, everyone.